All right. Well, thank everybody for coming today. I really appreciate it. We're going to wait for a couple more guests to come down the walkway. Angie will just let us know when we're good. All right. We're going to have Director Bill Lacey say a couple words.
Thank you, Ethan. I just wanted to come and thank everybody for coming to the discussion group today, but I especially wanted to thank Ethan. He's been our spring fellow. He's done a wonderful job. He's had great guests. The guest today is terrific, too. If you want to hear a good story about climbing a mountain, he can tell you about climbing Mont Blanc. I'm not sure what else maybe he could talk about on mountains, but I'm sure had some interesting stories. But Ethan, I just wanted to say thank you so much for doing such a great job with this discussion group and being such a great fellow. It's been a lot of fun having you around, and I want everybody to join me in thanking Ethan for the hard work that he's done to make this group successful this spring. And it's all yours.
Well, thank you. I really appreciate that, Bill. It's been a real honor for me to be the Dole Institute Spring Fellow. I think that this institution is such an asset to the university, to Lawrence, and to Kansas as a whole. And I think that all of us could just benefit from, whether it's trade or something else, of having more conversations like the ones that we've been having, where we're all collectively digging for a deeper understanding and a better understanding of these complicated issues. So I really appreciate those of you. I mean, we've got a lot of familiar faces here who've been with us since our first discussion group, and I hope everybody feels like they're now at the end with a little bit better understanding of what I think is a real timely and a real relevant and really important topic for us. But again, whether it's trade or something else, I think collectively as a community, it's really important for us to continue to have these sorts of conversations. And so that's why I'm really grateful that we have places like the Dole Institute where we can have these kind of conversations where we're not yelling or tweeting, but we're really trying to learn and all have a better understanding of some of the important issues and challenges that we all face. So as I mentioned, this is our final discussion group, and today we're going to be talking about the enforcement of trade agreements with John McInerney, who's currently a counsel at the law firm of Mayer Brown, where he's a member of its international trade practice. And so when I thought about how to structure these discussion groups, I purposefully wanted to talk about enforcement at the end of the discussion group, because it really ties together so many of the different things that we've talked about throughout these different sessions. So if you remember our discussion groups, we had Arun Venkataraman, we had Antman Trivedi, and they talked about how our trade policy is taking a turn towards protectionism. We talked about how Congress is looking at trade agreements on the Hill. We talked about that with Jordan Haas. And last week we had Megan Grube, who talked to us about some of the messaging challenges that we've had around trade and how what we're hearing from a messaging perspective affects public opinion. And so I would argue that what ties together all of these different areas and issues that we've talked about is enforcement. And that one of the reasons I think that the public has taken a less positive view of trade in recent years, and that members of Congress have reacted accordingly, is skepticism that the U.S. has the ability and the will to enforce trade agreements. And this widely held belief that China is a bad actor when it comes to complying with its obligations. So I really wanted to conclude this discussion group by leaving everybody with an understanding of the different ways that trade agreements can be enforced and how the Trump administration has used these mechanisms. So here's examples of what I mean when I talk about the central role that enforcement has on everything that's going on around trade. And this is from yesterday's Washington Post. House Speaker Nancy Pelosi suggested Tuesday that President Trump must reopen talks with Canada and Mexico to tighten enforcement provisions in a proposed North American trade deal, casting renewed doubt on prospects for congressional ratification of the accord. No enforcement, no treaty, she said, offering some of her most pointed remarks to date on the fate of a measure that the administration has labeled a top trade priority. Last week, Speaker Pelosi told reporters, quote, "We need to see enforcement. I've said it all along. It's no mystery. You can say all the nice things you want in the world and write them up, but unless you have enforcement, you're just going down a path that isn't going to be helpful for America's workers." With respect to the ongoing trade talks between the U.S. and China, Senator Chuck Grassley of Iowa, probably the political opposite of Speaker Pelosi on so many issues, said this last week about the state of the U.S.-China negotiations. We've made great progress on intellectual property, on trade secrets, on their government not forcing our businesses to give them our technologies, and on currency manipulation. And Reuters went on to state, but the Iowa Republican, whose state has been hit hard by China's retaliation against U.S. tariffs, added that without an effective enforcement mechanism to hold China to its promises, quote, none of this other stuff matters. So that is why enforcement is so important. And there's nobody better to talk to us about trade enforcement than our guest today, John McInerney. John spent 31 years as an attorney at the U.S. Department of Commerce, the last 17 of them from 2000 to 2017 as chief counsel for trade enforcement and compliance. During that time, John was involved in almost every major administrative proceeding, negotiation, litigation, and dispute involving trade enforcement. John has briefed and argued cases before the U.S. Court of International Trade, the Court of Appeals for the Federal Circuit, NAFTA panels, WTO panels, and the WTO Appellate body. His work was recognized with numerous gold and silver medals from the Department of Commerce. John holds a law degree from the University of Michigan, and prior to joining the Department of Commerce, served as an attorney at the U.S. Department of the Treasury and in the Washington and Brussels offices of the law firm Cleary, Gottlieb, Steen, and Hamilton. He is currently counsel in Mayor Brown's Washington office and a member of its international trade practice. Please join me in welcoming John to the Dole Institute. So, John, you've had a long career as a government lawyer, first at Treasury and then for 31 years at the Department of Commerce. So, what motivated you to leave private practice and go into government work?
Well, when I started out going to law school, my real ambition was just to get involved in international affairs, and everything kind of really built around that. I went to a large law firm because I did well in law school and I could, and I thought that would, be a good next step, and it got me into Washington. But I don't think I was ever really cut out to do that. I never really, especially wanted to. I wanted to work in government, and so that's eventually what I did, and I had a lot of fun. I enjoyed it.
So what do you think? You've been in private practice as a young junior attorney and now in a more senior role. Talk about the difference between being a lawyer in private practice and being a lawyer in government.
There's a general consensus about this. The people in the government have more fun, and the people in the private sector make more money. One of the reasons I could afford to stay working in the government is that my wife was also a very successful government lawyer, and between the two of us, we brought in enough to support a family on. We also had the good fortune to buy our house 30 years ago before Washington real estate prices soared through the stratosphere. Things like that are important. A lot of people who really enjoyed working for the government got forced out just because the pay was so low. Or relatively speaking, we would have staff attorneys who'd been in our office for 3 or 4 years, and they would leave to go to the private sector, and their pay would be multiplied 2.5 times on average, sometimes 3. So if you got student loans to pay off, you don't really have the option to hang around. I was fortunate. I went to Michigan Law School. Tuition in those days was, I think, $600 a term if you were in state, and I was in state. I'm dating myself.
Got some students here who are...
It was not the 19th century, actually. It was the 20th.
So your role at the Department of Commerce was such an important one, and I really want to give everybody a sense of an understanding of the important role that senior career officials, as opposed to political appointees, play in the operation and the running of a place like the Department of Commerce, as far as having the importance of having continuity, the real depth of expertise that the senior career officials provide, and the important historical context. And I felt like when I was there as a political that there was just such an important role being played by the senior career officials. Talk to us about that.
Well, there's no question that the senior career people typically have been around 20, 30 years or something like that, and it can be a little dicey when the new political people come in, because they think, well, so some of them are experts.
Present company excluded.
Yeah,
but
some of them are
yeah.
experts when they come in, but some are not, and a lot of times they come in and they think these people know a lot, and maybe they're going to play me. Maybe they're going to lead me, around. And meanwhile, I belong to a political party that just won an election. I've got, a program to implement or what have you. And at first, there's a degree of distrust there. And then, usually you work it out, and after 6 months or a year, if you do your job, you can earn their confidence and their trust. They also learn a lot more, and pretty soon they don't think they need you anyway, and sometimes they sort of don't, although it's with a lawyer, it's good to have an outside lawyer. What they say about people lawyers who give themselves legal advice, that they have a fool for a client. There's kind of a built-in tension there, where lawyers deliver the bad news. And sometimes the best way, to deal with that. But there's always going to be a little tension between lawyers and clients and the government, and that's natural, and it shouldn't be viewed as a problem in my view.
So we've got some incredibly talented students that are with us here today, and some of them are at the point where they're probably thinking about what's next for them and how they want to start their careers. What advice do you have for students who are thinking about government service as being some or part of their professional career?
Well, as I said before, it tends to be fun. It's interesting. The people you're associated with in Washington are all very bright, talented people that come from all over the country, and it's just an interesting thing to do. And the money's not that good. The standard advice that I got when I was a student was, we're kind of asking this one professor, what do we do, and how do we pad a resume, and does this look good, and does that look good, and all these kinds of questions. And this guy had lost patience after a while, and he said, look, you want a feather in your cap? I said, I'll give you a feather in your cap. Find something you like and do it well, and don't worry, don't get too crazed about the rest of this stuff. It's not that important. I still remember that and still think it's good advice.
Well, so I want to talk now about the topic that you gained so much expertise on during your time in government, and that's enforcement of trade agreements. And like I said, it's important for us to leave today with an understanding, once ink dries on a trade agreement, it's been ratified by Congress, and it goes into effect, what are the mechanisms available if one party to the agreement feels like the other party is not fulfilling its obligations? So first I want to talk about some of the different ways that trade agreements can be enforced, and then we'll talk about how the Trump administration has used those. But first, why is enforcement of trade agreements such an important part of our global trading system? Why does enforcement matter?
Well, if people don't think that their agreements are going to be enforced, if they think that they're going to live up to their obligations and their side's not, then of course the whole system will collapse. So enforcement is fundamental, and it's really not much more complicated than that. There have been periods, free trade kind of ebbs and flows, goes in and out of style a little bit. At the moment, it's sort of ebbing. But there was a time, say, 20 years ago when, you just couldn't sign up the whole world fast enough. And, the more deals that you could sign, the better. And people weren't terribly worried about enforcement. Not as much as they are today. Now, of course, pendulum's swung the other way, and you hear about enforcement all the time. As a matter of fact, the part of Commerce that I used to work for was renamed. When I started out there, it was called the Import Administration. And a couple of years before I left, so this would be 4 years ago, they changed the name to Enforcement and Compliance. That was a new name, but enforcement was a buzzword by then, and it had not been quite so much, before. Not that people ignored enforcement, but it was the emphasis was not the same.
So let's talk about some of the different government entities that are responsible for doing the investigation and the enforcement of compliance issues. So who in government has their hands in enforcement?
A lot of people, sorry, a lot of people, do we want to talk about countervail? Do you want to go through things one at a time? Or do you want to...
yeah, I'll get to that, but I just want to first have folks
well,
understand which offices are looking at enforcement.
All right, well, the Department of Commerce is very much involved. The Customs Bureau is very much involved. The Office of the United States Trade Representative is very much involved. And there's an independent commission called the International Trade Commission that is involved in these subjects generally, but I mean, they don't have a direct kind of enforcement arm. They you know, hand down various types of rulings that result in duties, and customs enforces the duties. But they have an active role in this. So those would be probably the big four in the world of, you know, trade and goods that you would mention. And then there's all, you know, these agreements have all sorts of you know, sections that deal with services and capital and all sorts of things, investment, and you know, that's a little different. The Treasury Department is also involved in enforcement of, you know, but that's not so much trade in goods, and frankly, my knowledge doesn't go awfully far beyond trade in goods.
And so let's go to where you wanted to go, which is the anti-dumping and countervailing duties. So the U.S. government has the ability to take unilateral action against unfair foreign pricing and government subsidies that harm American businesses. And this is commonly done by imposing anti-dumping and countervailing duties. And that's kind of a mouthful. So first, what does it mean when for a good to be dumped? What are we talking about? What's happening there?
I'll try to do this in about a minute and stay well out of the weeds, as everyone will pass out. You know, dumping essentially is selling something for less in the United States than it's sold for in the home market. And, you know, it sounds relatively simple, but it's not. You know, if you take out sort of, you know, you've got your widget or whatever it is, you find out that what's sold in the U.S. market is actually not the same as what's sold in the home market. So you have to make adjustments for the differences. And then, you know, the currencies are different. You have to convert the currencies. And then the terms of sale are different. So, you know, you actually wind up with a computer program that's about 700 lines long. So, you know, it's complicated. And then sometimes dumping is, you know, if the home market sales are below cost, they're selling below cost, both, you know, say in their home market, you don't use those prices. So then, you know, you decide how far below cost they're selling. And then if you have a non-market economy, the home market costs don't mean anything, so you use a special methodology to construct a cost in their home market. So, you know, it's very complicated, but basically if you're selling your widget for $10 at home and $9 here, that's a $1 dumping margin. And, oh, my tape came off again. I'm going to my whole microphone came off. I'm sorry. So where was I? Yeah, you've got that, and I should mention that in the United States, these sort of dumping duties, most of them are imposed after a domestic industry in the United States files a petition. And trade remedies in the United States are different than they are in most of the world, because here it's an entitlement. Here, if you can show that the foreign company is dumping, and you can show that your industry is being damaged, you have an entitlement to relief. Now, in most countries, it doesn't work that way. They're less sort of legalistic. The governments tend to have more power and discretion, and they'll go ahead and they'll complete these investigations, and then the president will decide, or some council will decide, whether they want to impose these duties or not. Okay, that's not the way it works here. Here, if a petitioner satisfies the conditions for relief, they're entitled to it. So that's kind of a very, very quick overview. Another thing I should mention is if you watch the newspaper, lost it again, pretty soon you will see that you'll see a reference to illegal dumping. But as it turns out, dumping's not illegal. Foreign companies can dump in the United States, and there's no problem with it. But if their dumping causes injury, and someone files a petition, and dumping and injury are shown, then remedial duties will be imposed at the border as an entitlement. But dumping itself is not illegal, despite what you will read in the paper very frequently.
Well, so we've got some economics majors here, and so at first blush, it seems illogical that a company would be, of its own volition, purposefully selling products for either less than it costs to make them or for less than it sells them in its home market. Why would a company engage in dumping? Talk to us about some of the reasons that would happen, because it seems illogical.
Well, here the way it works, and this line of argument was you heard it more 20 years ago. Okay, free trade is good. Trade remedies are an impediment to free trade. Ergo, trade remedies are bad. That's the basic line of thought, and I'm not saying that line of thought is totally without merit, but the basic premise of that argument suggests that free trade really exists, and there's really no problem at the outset. That's just not true. If you look at the kinds of industries in which trade remedies are applied, you'll find out that there are these messed up commodity markets. Commodities like steel, uranium, cement, semiconductors, big commodities, and the markets in these commodities have been warped in all sorts of ways, in all sorts of countries, all over the world. And the cases are in part a result of that. Now, I'm not saying that every dumping petition that's ever been filed is perfectly meritorious, and that the petitioners aren't playing games with the respondents, and on both sides and so forth. But you will find that the dumping duties, which cover only a few % of imports into the United States anyway, you will find that they're concentrated in commodity industries. For your economics majors, you've all had the argument, you've all heard the argument that if, England makes all the sweaters and France makes all the wine, that, everybody's better off because you have more and better sweaters and more and better wine. Well, I had some economists try to explain this to me at the old executive office building, which is, part of the White House basically one day. But we were talking about uranium from Russia. And I was just dumbfounded. I get it about the wines and the sweaters, but I would say, are you trying to tell me that when, Leonid Brezhnev, we're talking about uranium from Russia, right? That when Leonid Brezhnev decided to build this cosmically gigantic plant to enrich uranium for atomic bombs, that he said, oh, wait a minute, guys, we better get the bankers in here, work out our return on capital, make sure that this makes economic sense, right? Okay, that's an extreme example. I admit that. But many of the other examples are much less extreme. But, in a lot of these industries, you do not really have open, efficient, and fair markets functioning. I'm not saying that, that accounts for every dumping case, but it accounts for a number.
And so how has the Trump administration used anti-dumping and countervailing duties? How have we seen them use that?
Well, they haven't really done too much in the, directly with anti-dumping and countervailing duties. I'll get to the self-initiated cases in a minute. But the history of dumping and subsidies cases was, it was very, very, very active area of practice with lots of remedies being applied until about 2008. Then when the financial crisis hit, things were so bad that the imports disappeared. And it wasn't that, people weren't dumping. They probably were more than ever, really, because everybody's desperate to try and stay in the market. But what happened was they couldn't prove injury because there just weren't enough imports. And so the practice went way, way down in 2008. It didn't recover till about 2011. By the time President Trump is elected in 2016, I mean, it was just going gangbusters. I mean, you know, you had a very large volume of cases. And these cases are, by and large, being filed by I mean, almost all being filed by U.S. industries, not really anything to do with the Trump administration.
You mentioned the self-initiated case.
But then there were these self-initiated cases, yeah. The Trump administration made a big splash saying how it was going to self-initiate cases. And I was there at the time, and you know, we said, fine, you can do that, but you got to keep one thing in mind. Self-initiating a case solves a number of technical problems, most having to do with not having to show that the domestic industry supports the petition. Once you self-initiated that case, it's just another case. You still have to prove that there's dumping, you still have to prove that there's injury, you still have to run through all this stuff, just like any other case. So the idea that a self-initiated case is something completely different is not, you know, exactly accurate. And they did self-initiate a number of cases on aluminum, and you know, that's okay, but not as big a departure as perhaps as it was you know, portrayed as being.
And did they prove dumping and injury in those cases?
Yeah, and I think some or most of them they did, yeah.
And then the World Trade Organization is sort of, we sort of think of it as kind of the cop on the beat for trade. But talk about what are its dispute resolution mechanisms? What role does the WTO have in enforcing or handling trade disputes?
Well, it handles a lot, and about my experience is in challenges to our anti-dumping and countervailing duty measures, our anti-dumping and subsidy measures, which account for, there have been over 500 cases in the WTO, and about half of them have involved trade remedies, mostly from the United States. So, I mean, there's a huge volume of dispute resolution involving U.S. trade remedies. And but there are other WTO cases as well. There are some trade agreements that give rise directly in the WTO to remedies. Our cases involved, you know, agreements that control our exercise of authority under our dumping law and our subsidies law. So we have entered into agreements in the WTO that say when we impose remedies on subsidized and dumped imports, you know, we will observe the following rules. And our statute has been amended so that it is, in our view, entirely consistent with those rules. But when the United States imposes, you know, a dumping or a countervailing duty measure, very often the company or the foreign government against which the measure is imposed decides that the United States has not followed the rules, and they challenge that in the World Trade Organization, and there's a very elaborate procedure there.
And and you talked to us, do you want to talk about some of the highlights of that procedure and kind of what that looks like a little bit?
Yeah, well, briefly, the first stage is consultations, and this shows you the historical, you know, roots and heritage of the WTO. It was in the beginning entirely a negotiating body. You know, it started out as a general agreement on tariffs and trade in 1947, and then everybody had all these commitments to bring all these trades, you know, these tariffs down and promote free trade, and it was very successful at that. You know, tariff rates have come down. The amount of world trade has increased. It has been sort of a big success in promoting world trade. So when a dispute is brought, the first stage is to have consultations. And before 1994, there was no binding dispute settlement. So consultations was really all there was. After '94, and what was called the Uruguay Round Agreements, you know, if the settlements, I mean, if the negotiations didn't work, then one side would bring a dispute against the other. And, you know, this is a kind of a classic dispute, sort of not exactly a courtroom. It's a WTO panel over in Geneva, but there's briefing, there are hearings, you know, it goes on, and then eventually you get a decision, and then there's a potential appeal to the appellate body of the WTO, and then after that there can be a compliance procedure. The panel will recommend that if you lose the case, the panel will recommend that you bring your measures into compliance with your WTO obligations, and then typically they'll be dissatisfied with whatever the losing party does to do that. So then there'll be something called a compliance proceeding after the appeal, and ultimately, if the offending member doesn't bring its practice into compliance with the WTO obligations, then the complaining party will get to basically impose punitive tariffs, retaliatory tariffs against it. This is called suspending tariff concessions, but it's really, it's retaliation. And countries are very clever at how they retaliate. They're consultants who specialize in this. And they will, for instance, if they're retaliating against the United States, they will decide, let's say if the U.S. industry involved is from a certain area, they will retaliate in such a way as to hurt industries in that same congressional district. It really gets very sophisticated. They don't want to just retaliate against a certain amount of imports. They really fine tune it.
So what do you think are the strengths and weaknesses of the WTO dispute resolution process? And do you think it's working pretty well? Are there ways that we could make it better?
It takes a long time, and remedies are a little bit uncertain, and there's also this problem that the United States has had, in that there is a different view of how to interpret international obligations. I can remember when I first started going to Geneva regularly, and it was 4 or 5 times a year after 1994, once the binding dispute settlement started, I would have these discussions with these other lawyers in Geneva, in the WTO coffee shop, and they would say things that I found very hard to follow, and I'd say, no, wait a minute here, let's see if we can, agree on some basic principles. I said, we don't impose, dumping and countervailing duties because the WTO gave us permission. Our dumping law goes back to 1920, and the GATT didn't come around until 1947. We're imposing these duties as a sovereign nation. So let's just take a hypothetical case. Let's suppose our law has 10 provisions, 1 through 10. And we sign an agreement, and we agree to the restrictions on how we will exercise that authority. Say we agree to restrictions on 3, 5, 7, and 9. Now, as for the others, 1, 2, 4, 6, 8, 10, we don't have any obligations. There's no WTO law on that. No one can bring a case on those issues. Those are just skipped over. There's no law to apply. Therefore, there can be no dispute on those. And they would look at me and they would say, John, you know nothing of international law. I would go, really? Uh-oh. I thought I knew a little bit, but, And you have this conversation 2 or 3 times, and then you would really start to think, uh-oh, I really, And they would, their view is there really is no limited, judicial review. There really is no limitation on that. Once you agree to limitations on 1, 3, 5, 7, and 9, it really covers everything. There are implications throughout the agreement. You've really ceded sovereignty over this area to the WTO. And I'd be going, wow, that's amazing. And, they would think, well, John, you're just not the sharpest knife in the drawer, or maybe you didn't work hard enough. And if you really thought about it really hard and you burned incense, you studied it, you'd realize that actually the United States has obligations here. And of course, the way this played for a lot of people in the United States government was, oh, I get it. They're making up obligations that we never agreed to and imposing them on us. And this is a cute story they made up to go along with it, And this is, was a point of contention for a long time. It didn't start with the Trump administration. And the result of it was that at the end of the Obama administration, when one of the appellate body judges hit the end of his term, a judge from Korea, the Obama administration refused to confirm his successor. And the Trump administration has continued it. And there's now quite a shortage of appellate body members. And at the end of this year, there will be not enough appellate body members to decide a case. And that not only shuts down the appellate body, it also shuts down the basic dispute settlement system before WTO panels, because they can't enforce a remedy until you've exhausted your right to appeal. And since no one will be able to appeal, it means they won't be able to enforce any remedies. So the entire WTO dispute system is in jeopardy of being shut down at the end of the year. It's kind of like a Brexit, for the WTO dispute settlement system. And so that's all very, very interesting, but it comes out of, in part, a fundamental disagreement about how these international obligations are viewed. It's a very interesting thing, and if you watch the papers as the year goes on, you'll see the cries are going to get more and more shrill as the appellate body, tends to, stop functioning.
So one of the things the U.S. has done is since 1989, every trade agreement that the U.S. has been a party to has had, as part of the actual agreement, a dispute settlement procedure. Why is that become something that the U.S. is pushing for in trade negotiations, instead of just saying, we'll just let the WTO take care of it? Well,
not all trade agreements are actionable in the WTO. I mean, if you look at the WTO agreements, they're this thick, okay? And there's an agreement on dumping, there's an agreement on subsidies, there's an agreement on safeguards. There are agreements on a lot of subjects, but there are a whole lot of subjects that aren't touched. And so if you want to have an agreement on one of these other subjects, well, you can't enforce that in the WTO. I mean, they're pretty liberal in what they'll do, but they're, let's say you have I'm just making this up. I don't think intellectual property is covered at the moment. And you can't just bring a WTO case, on that. There has to be some law that they can at least claim they're applying. So, there are a lot of areas with that where there is no such laws. So if you're going to have an agreement on one of these other areas, you have to have your own enforcement provisions in it.
So is it just they're trying to fill in subject matters that aren't covered, or is it also that there's just the U.S. is trying to bring to bear a philosophy about enforcement that is maybe different than the WTO, and they want to try to embed that philosophical approach to trade enforcement in those agreements?
It's both. It's both. I mean, there are a lot of subject matters that aren't covered in the WTO, okay? And the WTO concentrates mainly on trading goods, and a lot of that is covered. There are other things that are not, but also, enforcement is really, as you say, the emphasis on it has grown and grown and grown. And I mean, moving away from just sort of dumping and subsidies, there are problems. Say, let's take a dumping duty on some product. Let's say it's some steel product, okay, or some product that's, I don't know. Let's say automobiles or something. If you have a dumping order on, automobiles from country X, what happens? I mean, well, typically you find the same automobile starts showing up from country Y, okay? Now, maybe they take it to country Y and change the label. Okay, that's circumvention of the original order. That, at least in theory, is actionable. But what if they just rearrange their production process and they really start supplying the U.S. market from country B instead of country A? There's really no remedy for that. And, with the world economy constantly expanding and spilling over national boundaries all the time, these laws, like the dumping law and the subsidy law, which are based on kind of like a 19th century model where a widget comes from one country instead of having been assembled with parts from 10 countries, these traditional remedies really are not so effective. So the Trump administration has turned to older remedies that in many cases hadn't been used in 10, 20 odd years, and started using those instead because they are much, much broader. Now, of course, the United States trading partners regard most of these as inconsistent with their international obligations. There are cases in the WTO on that and so forth. So, it's going to be very interesting, but
one of those is Section 201. We talked
Yeah.
and so I want to talk to you about this. Is Section 201. These are what we're calling the quote safeguard investigations. Talk to us a little bit about those, what those are, and how the administration is using Section 201.
Well, there were in 2018 there were so-called 201 remedies applied to solar cells and washing machine parts, and 201 is what's called the safeguard statute, and it's not involved. It's not dependent on the finding of any sort of unfair trade practice. It's
Unlike an anti-dumping,
unlike
to go
an
back,
anti-dumping,
anti-dumping, you have to have
subsidies,
that.
right,
You have to
those
make
are-
that showing.
Those are remedies for unfair trade practices. 201 safeguards are simply duties that respond to a surge in imports, and they are designed to prevent serious injury or the threat of serious injury. And also, unlike dumping duties or subsidy duties, they're not targeted as specific industry or country. They apply to all imports. So these recent 201 duties applied to basically the full range of imports on these, and then they're not confined to really just being duties. They could be tariffs or quotas or tariff rate quotas. They could be a lot of different things. They could last different amount of time and so forth. But and also under 201, it's clear that the exporting countries can retaliate and are probably going to. Nevertheless, you can sort of do this. So this is happening now. It's one of the three kind of not quite so normal trade remedies that are being used at the moment. You'll get to the other two, 301 and 232. But they're part of this broader pattern we're seeing at the moment where the Trump administration has essentially concluded that the traditional remedies aren't really getting the job done, and that they're just going outside the box here. There are going to be some consequences, but they'll, worry about that as they go along.
So you talked about 301. Let's go there next. Section 301 of the Trade Act of 1974. What is Section 301? How does that work?
Section 301 is part of a 1974 statute. It applies to the Office of the United States Trade Representatives. I think, I'm not an expert on 301, but I think in the beginning it was really designed to give USTR authority to enforce trade agreements. And then it was, rewritten a few times. It was called Super 301, in a few different iterations and so forth. And it kind of gradually expanded so that it now can be applied for violations of trade agreements or just to counteract any unreasonable restraint on trade. So it's really gives the president broad authority to impose remedies, on imports. And
How is President Trump using that?
well, these are the ones where when you heard that President Trump imposed these 10% duties on $20 billion worth of imports from China, this was done under this Section 301. That statute hadn't been used in a long time, but it's being used against now, and it was being used to bring China to the table on their complaints about China pirating international property and things of that nature. So it's along with the other statutes we've mentioned, this is one of the tools they're using. Part of the theory is the trade deficit with China at the moment is over $400 billion. So the idea of the Trump administration, I certainly don't speak for them, is that China understands that they will not really win a tit-for-tat, retaliation game on tariffs because we import 400 billion more from them than they import from us. So they impose a certain amount of duties on our imports from the United States, and we impose duties on imports from China, and then, so they do some more and we do some more. Well, guess what? They run out of imports, and we've got 400 billion left. So, nevertheless, no one really wants it to get to that. In the meantime, there'll be substantial damage to the world economy. But the threat is clear. The deficit, gives the United States kind of a built-in advantage on imposing tariffs.
I want to get into China in more detail, but the last thing, I want to talk about 232 and how the president is using national security justifications to also impose some trade restrictions and tariffs. Talk to us about that and why that is both controversial, both from a legal perspective and also from just a foreign policy or political perspective.
Well, 232 is a statute that is administered by the Department of Commerce, and it is a national security statute, and it allows the president to, impose duties to protect national security. And this statute hadn't been used since the 1980s. And you've probably heard about the universal duties that have been applied on steel and aluminum. These were done under 232, and they apply to imports from all countries. Well, there's 3 or 4 exceptions, and some qualifications there always are in these matters. But 232 was the tool that was used. So, without getting into too much detail, you see the same pattern here. You have the standard remedies that have been used for a long time, and you had particularly the Trump administration concluding these weren't getting the job done. So they went down and saw what their other arrows in their quiver were, and they had 301 that USTR could use to impose the duties on China, and then you had safeguard that you could get a recommendation from the International Trade Commission, and the president could impose duties on solar cells, and then you have 232 where Commerce could do this national security investigation, and that's where the duties for aluminum and steel came from. So you have, if you step back and look at the big picture, a conclusion that we're going outside the box to get what we want here.
And potentially 232 would also be the potential tariffs on autos, right? Would also be under that 232.
There is an investigation going on now on autos, and apparently there is one on uranium.
So having worked at Commerce, how do those investigations work? Because there is a criticism that they're sort of working backwards from the conclusion that they know that the Trump administration wants them to have, and then that the report that they're doing is more of a justification for them to impose those tariffs on national security grounds. How do you look at that?
A lot of people think that, and I'm not going to say there's no element of truth to that, but it is instructive to compare the United States procedures with procedures in other countries. What you have in the United States is a vast amount of transparency and due process and really rigorous judicial review. You don't really see these in other countries. So the way the Commerce Department does one of these cases is, if you think about it, I mentioned earlier that, the 700 lines of computer programming or whatever it is these days to make sure you're comparing apples to apples, to make sure it's the same kind of apple and the terms of sale were the same and the date of sales were comparable, so you're comparing two things that are alike, and you have this elaborate computer program. Well, the way you conduct one of these investigations is you send the foreign producers a questionnaire. It's a huge, long, detailed questionnaire, very, very burdensome. And of course, the department says, well, you don't have to fill this out, but if you don't, we'll have to make adverse assumptions about what your answers would have been, which will result in very high duties. So suit yourself, but obviously we can't compel you to answer it. So then they answer that, and the department goes and conducts a verification, which is kind of an audit to make sure the answers are accurate. They come up with a preliminary determination, and then everybody gets to file briefs arguing about it and commenting on it. But the key thing is the lawyers involved here can get access to everything under administrative protective orders. So the lawyers for the foreign parties and the U.S. parties, they can all set this up on their own laptops and run the numbers themselves. And they can look at how every little adjustment works. I mean, the transparency is remarkable. It's 100%, basically. So, as I would sometimes...
But it's not transparent to the public because we haven't seen that report yet, right? We haven't seen the report on autos.
Not the proprietary data. Wait a minute, this is dumping now. We're not on autos, okay? That's different. But I'm just, in terms of the trade remedies, the lawyers involved have 100% transparency. In most countries, it doesn't work that way at all. In most countries, it's more or less of a black box. The administrators pull a number out of a hat, and then you go have lunch and make a deal. And sometimes the foreign exporters would rather do it that way, frankly. I mean, they're very impressed with the U.S. system. They're very impressed with the amount of due process they get. They're shocked by the transparency, which is one of the most shocking things you can have in a lot of countries we're talking about. But a lot of countries, they'd rather just say, oh, God, your due process takes years and years and years, and your judicial review takes longer than that. And, frankly, we'd rather go have lunch and just cut us our share, and, if we don't like it, we'll retaliate against you somewhere else. That's the way business is done in many parts of the world. And it has the virtue of being quick and, kind of predictable. And, you can see why people get a little tired of the American brand of justice. People will litigate this stuff out to the third decimal point for, years. And I do mean, years.
Mm-hmm. Now, I wanted to dig in a little bit on China before we go to questions. And so the Chinese are in Washington, D.C., meeting with Ambassador Lighthizer and trying to come to a final landing point on the U.S.-China trade agreement. First, and this is more of an opinion question, one of the things that you read a lot is that part of the reason that there has been this resentment in the U.S. domestically about free trade, and there's been this shift in public opinion where people feel like less supportive of free trade, that free trade on net has not been a good thing, and that we've seen public opinion shift. There's a school of thought that part of that is because people have felt like for years and for decades now, China has been a bad actor in the trading system, and that China has been willfully not living up to its obligations, and that has built in America domestic resentment against free trade. What do you think about that?
Well, it's very hard to comment on. I mean, if you look in the media, you'll see many reports about China appropriating intellectual property, for example. It's not my area. I'm not an expert, but I read the newspapers too. I've seen these reports too. I'm not an expert. Their system of dumping and subsidies enforcement is, of course, less transparent than ours. That's true of many countries. So I don't know. I'm not sure I have a simple answer for you there.
So where do you think, when you look at it, and we're all going to be kind of following this in the next coming weeks, when you look at the U.S.-China deal, what do you think that is probably going to happen from an enforcement perspective? What do you think the parties will agree on? What should we watch? Because obviously the U.S. is going to be pushing for more robust enforcement, and what do you think China will agree to? What do you think their lines in the sand are going to be?
I don't know. I mean, the enforcement is simply, I can tell you how that's going to work. They're going to say, first of all, we're not taking the extra duties, and here, with China, we're talking about the 301 duties. So this is USTR, and Bob Lighthizer is the special trade representative, or the United States trade representative, as it's called now. I think one of the proposals is they'll simply keep those duties on until China has complied, or at the very least, they'll put them, to the extent that they are taken off, if they feel that China is falling back on its obligations, they'll reimpose them.
And is that something you could see the Chinese ever agreeing to? Do you think that that's an agreement the Chinese would sign?
I don't know. I mean, it's pretty tough. I mean, if you think about it, think about coming into to another country and sitting down at the table, and they say, the enforcement mechanism of under this trade agreement is just up to us. We'll decide whether you're complying or not. There's no dispute settlement body. There's no court. There's no arbitration panel. We're going to decide, right? Typically the other side would say, you're crazy, it's a non-starter, we're out of here, right? I mean, that would be, on the other hand, there is that $400 billion trade deficit. So, maybe some sort of formulation will be worked out. I certainly don't know, but I do know, a little bit about it, and that's about the extent of it.
Yeah, because what's being reported seems like it would be very difficult for the Chinese to go back to their domestic political audience and consider that a win. What's being reported is that Ambassador Lighthizer is, if you described it, said, we want an agreement where we can impose unilateral tariffs on you if we think that you're violating the agreement. You cannot impose tariffs back on us, and we get to essentially decide whether or not we think you're complying with that agreement. To your point, that seems like a hard thing to take back to your domestic political audience and say that that's a win.
Well, it's impossible. At least has to be disguised. But we'll see. Another thing should be mentioned. You were bringing up enforcement and also mentioning we have economics students here and so on. If you're going to talk about trade balances, it's really remiss not to bring up exchange rates, because exchange rates are key, right? And this has been a major subject with China over the years. The Treasury Department has done a lot of work trying to talk China into, raising the value of its currency and lowering the value of the dollar. Trade remedies affect, 3 or 4% of imports into the United States, and you could say, okay, there's kind of a shadow effect, a penumbra or something. Maybe those effects really extend to 5 or 10% of imports. Okay, but exchange rates affect everything. Services, every product, everything. For most countries in the world, if they had the kind of trade deficit that the United States has, the value of their currency would decline, which would make their goods cheaper and they would export more. It would make imports more expensive, so we would import less, all right? But for various reasons, because we're the reserve currency of the world and because people love to park money here because it's a safe place, and for lots of reasons that are, over my level of expertise, it doesn't really happen. And the dollar's a lot stronger than it would be if we were another country. And that is probably one of, the largest or the largest driver of the trade deficit. But it can't really be fixed. So everybody knows, and people like Ambassador Lighthizer, fully appreciates this point. Nevertheless, they're doing what they can on the trade in goods and front.
Mm-hmm. Well, let's take some audience questions. What questions do we have? Let's wait for the microphone. Haley's got the microphone. Questions?
So you touched on intellectual property, and as someone who's interested in law school, I know that that's kind of a growing area of the law with tech industries. So do you think that that's going to be something that trade attorneys like yourself are going to have to start dabbling in? Are intellectual property lawyers going to be part of the negotiation, or is this mostly just a concern with China?
Oh no, intellectual property is big. China is the most often complained about party, but intellectual property is big, and intellectual property law is big. It's not an easy area to dabble in. You have different areas. You have patents, and you have trademarks, and so forth. Patents is really an area for engineers who then go to law school. Patents is a very technical area, very lucrative. But you really need to be an engineer who then decides to go to law school. Trademarks is also big, less technical than patents, and none of this is limited to China. China's just kind of the most famous player at the moment.
Dan, you had a question?
So you talked a couple times about China stealing intellectual property, and question was related to that. And then earlier the indication was that our current policy that's been created by President Trump has dealt with putting tariffs on imports, and then earlier you made reference to a more traditional approach to how to alleviate that, how to address that kind of stealing of intellectual property by Chinese companies. What was the traditional approach that you kind of talked about earlier or alluded to, and why do you think it wasn't working, or was it working?
I'm not sure that I completely understand your question, or that to the extent I understand it, I can answer it. I can tell you, let me just offer a very general observation, okay? If you go back to, say, 1950, the United States controls something like 1/2 of the GDP of the world. And now that number is more like 15% and declining, okay? So you had this artificial situation after World War II because Europe had been destroyed, Japan had been destroyed, China had never been developed, India had never been developed, South America really hadn't been much developed. You had this strange and artificial situation where the United States had half of the world economy. And I think people just didn't worry about this stuff that much. Now we're returning to what I would call probably a much more normal situation. And if you get out your globe and look at it, there doesn't seem to be any obvious reason why the United States should control half of the world's economy. And so these things which people didn't worry about so much anymore, so much to begin with, are now big problems. And then you look at China. I mean, if you go back to 1950, they just had the revolution. They just had World War II. They weren't a threat to anybody. Well, now, of course, they're a threat to everybody. So people are worrying about things a lot more than they used to. There are probably lots more to it. I'm just skipping over, but I don't think it hurts to put it sort of in a big, broad context.
My question is, do you have an opinion with respect to Trump's threat to close the southern border and what effect it will have economically on the United States of America and the world?
I'm not really here to offer personal opinions on disputes that I might be called to get on one side or the other. I doubt that they're really going to close the border in a very long term. I mean, there would be a lot of adverse consequences from that for both sides. Certainly us. I mean, the amount of trade is enormous. Mexico is one of our largest trading partners. There's all sorts of manufactured products that, by the time the final car or refrigerator or whatever it is emerges, the components have been back and forth across the border several times. A while back there was a book by a guy named Thomas Friedman called "The World is Flat." It made a big splash. Everybody was reading it, and it documented this sort of stuff. That this view that sort of you have a particular product that comes from a particular country. It's pretty true for agriculture, but if you get into manufactured products, it tends to be not true at all. And this sort of 19th century notion that products come from a specific place is just less true every year.
Well, I asked you if you have an opinion because on the news before I left to come here today, they were saying that should he close the border, the auto industry would probably close in the United States and Canada and Mexico within 4 days because they no longer stock parts. They don't have the place to stock parts. They all work on the theory that parts arrive and we immediately use them.
Right.
So we don't warehouse, we don't stock them, and within a week's time, the auto industry in this northern hemisphere would close.
Yeah, well, I share your skepticism that it's actually going to happen, okay? Let's just say that. Well, I am, okay.
Trump is, I don't know, he's a wild card. The news said his latest opinion was he'd close the southern border despite any economic harm it might cause. That's his latest statement on it.
Yeah, I'm not holding my breath on that one. Let's just leave it at that.
Okay.
There would be a lot of adverse consequences.
How does your work now compare to your work at Commerce?
Oh, well, it's much more focused on narrow problems. You know, you get a client with a particular issue, and you focus on that issue and contribute to a little team of people trying to solve it. Commerce was very interesting because one of the things about working for the government is if you wanted to get something done, I mean, occasionally I'd say we would try to settle one of these cases. We'd be trying to work out an agreement. For instance, I worked on one with Mexico about cement. Well, you wound up having to coordinate with 5 or 6 other agencies in the government. You'd have to go talk to USTR because you'd be relying on some of their authority. You'd have to go talk to the Justice Department about the antitrust implications of it. You'd have to go talk to Customs about enforcement. You know, and so on and so on. You have to go talk to the Justice Department about potential litigation or litigation that might be relevant to it. And everywhere you'd go in the federal government, you get these people who are, you know, highly expert in their particular area. And you'd go there and they would just say, well, all right, let me tell you the, 10 reasons why that's a dumb idea, and the most aggravating part of it is they'd usually be right? You'd kind of go like, all right, that's 9, I get it, let's find another way. It's very, very educational and very interesting, but you had to get used to this fact that the world's an extremely complicated place, and that complexity is reflected in the federal government and sometimes reflected directly in one of these agreements or statutes that you're trying to work on. Tremendously complicated. So it's very educational and therefore interesting and fun, but also frustrating.
Here in Kansas, we produce a lot of dairy products, and so this is a Kansas-related question. I know with the impending USMCA agreement, we've, in essence, opened up markets for dairy products to be put into Canada, and in the past, one way they protected their dairy markets is prevented other countries from bringing dairy into Canada. And here, one thing we do is we subsidize a lot of our dairy production in the United States. Now that we're actually putting dairy into Canada, do you think it's going to start opening up a lot of criticism for our subsidizing dairy products here, and could that lead to a trade issue later on down the line?
Yeah, the answer is I don't know. I am aware of the dairy provisions. I mean, you can make a general observation about agriculture around the world, okay? If you go back to 1950, if you go back to let's go back to 1900, right? In every country, agriculture is like, I don't know, some massive percentage of the entire economy, 80% or whatever it was. And then that number comes down, 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 down. Now it's 5 or 10% depending on your country, okay? But in every country, the political power of agricultural producers is much more reflective of their historic position as opposed to their current position. And in the United States, that's amplified by the fact that you have lots of states with relatively low population and large agricultural production. This is just the way it is, and in Europe it's even more so. In Japan, I mean, you can't talk about rice in Japan. It's religion. It's very, very difficult. So everywhere in the world you have these situations, and people are gradually addressing this subject, but it's difficult. And yes, we will be criticized for our practices. Yes, we have subsidies. So do they. Maybe theirs are bigger than ours. That's often the case. So we'll have tit for tat disputes. It'll go on. It's not going to be ironed out very easily.
We've probably got time for one more if there is one, and then otherwise we'll wrap up. We got one in the corner.
Yes, permit me to project for a minute. We hear an announcement a week from now that we've just obtained the greatest trade agreement with China that could ever be foreseen. That trade agreement would preclude China from violating intellectual property. How would we look at that agreement from the question of how so, from an enforcement perspective? What would we look for in that agreement to suggest whether that's hot air or there's some meaning to that?
It's like, what does compliance look like, right? If I'm
Right.
understanding the question, what do you look for as an enforcement compliance attorney? What does compliance look like?
Well, you know, it varies from agreement to agreement. For your intellectual property theft, I don't know. I think it would be anecdotal. I think you would have to go, people would go around and talk to the big intellectual property producers and ask them if they think they're still being ripped off. I mean, I think it would really be that. In other areas, it can be kind of quantitative. Like, let's say you put
In more physical goods areas,
yeah,
right?
in the physical goods areas, it can be more quantitative. Like what Commerce often sees is, let's suppose you put a dumping duty on, you know, red steel from France, okay? And you put the duty in force and, oh my gosh, red steel from France is gone. But, oh, look at that. Red steel from Germany just doubled, see? You know, and it's been called the whack-a-mole game, you know, and I guess you could look at overall trade statistics, you know, I mean, but that's what led the Trump administration to take this unusual step of imposing these, you know, broad duties under 232 that hit steel from all countries. And I guess the way to look at it, you could say, well, let's look at the overall balance of trade in steel. Or if you wanted to judge the Trump administration as a group, in 4 years, you could say, well, what was the trade deficit coming in? What's the trade deficit going out? Well, we know that the trade deficit is actually increasing, okay? But what is, you know, how much of that is the result of shifts in exchange rates, which might be vastly more important than anything that anyone's doing. So it's a good question and a difficult one. The answer certainly varies from product to product and area to area. Intellectual property would be extremely difficult. And I'm guessing it comes down to anecdotal. You know, who's complaining? You go to the major players who are complaining, the people who historically have believed they've been ripped off the most, and see if they think they're being ripped off less. Are they signing more licensing agreements? Are they seeing, you know, fewer pirated products out there in the market? I don't know that there's any statistic you'd be able to go to.
That was a great question, and you said something in response to that I think was really interesting. And can you talk just generally about the relationship between enforcement and compliance and U.S. industry, and how there is a relationship where, to your point, that you need to be able to have conversations with them, to talk to U.S. industry, to get their input on what they're seeing, what's happening in the market. Just talk more broadly. That was a great question to get us there about that relationship and how you rely on U.S. industry to sort of be somewhat your eyes and ears as to what is going on and how that works in government. Well,
U.S. industry is very, very vocal and aggressive in defending and promoting their interests. I mean, yeah, again, it varies. At the Commerce Department, you know, they can just file a petition. If they come in and they're complaining to us, we say, well, you know, they're your lawyers. We know them. You know, hi George. You know, what, are you guys filing or what? You know, and then increasing.
And it was washing machines and solar panels, for example, right? That was Whirlpool, I think, was who filed one of the petitions about that led to the.
But those weren't, yeah.
The washing machines eventually, right? Against Samsung and LG.
Right, and so exactly. But that's 232. We start out with dumping. So dumping, you know, you file a formal petition. 232 is, you know, it's an unusual remedy. So, but they would come in, you know, and talk about it. In the dumping and subsidies area, they have a right to file a petition. 232, you know, at the end of the day, you know, there's a recommendation to the president, decides what to do. So it's much more discretionary. Same under 301 and 201. So it's different. The people come in, they got to, you know, eventually they got to go talk to the White House. You know, they may talk to some other people first, but you have an ultimate decision that's sort of discretionary there.
Yeah, let's grab the microphone and then.
Sorry. Hi, just a follow-up with that question about filing petition. Use Samsung, LG as example. So the industry will file petition to White House or U.S. Department of Commerce, Or
No, no, no.
WTO or Korea government? Which one?
The 232, again, it varies depending on what the remedy is. The 232 proceeding is conducted at Commerce, and is probably conducted at the behest of our industry. But you know, it just varies. Dumping and subsidies, the areas I know best. You know, that's a very formal procedure that's been used a lot, and you know, for many years. The other stuff is a bit more, you know, it's been episodic. You're talking about the safeguard, because you were mentioning, what was that, washing machines? Yeah, that was a safeguard. That was a 201. So that petition was filed at the International Trade Commission. But again, see, then they make a recommendation. You know, the International Trade Commission doesn't have its own really enforcement arm. They make a recommendation to the president. Then the president decides whether to impose duties and how long they'll last and so forth. And Customs collects the duties at the border. So it's very different depending on which route you're taking here.
The regular, if I'm an injured party and I have the right to file, I could file a petition, the petition with the WTO though, on the dumping?
No, the petition is with the Department of Commerce. Okay. And then if typically the foreign respondent, or it's a government actually, would then challenge what Commerce does in the WTO. Now we never really got around to subsidies, which is okay, but in the world
Go
of...
ahead and talk about that. We've got a couple minutes. Talk about subsidies a little bit.
In the world of subsidies, there actually is a way to file a complaint directly in the WTO. And the big case here has been the Boeing-Airbus dispute. It's an example of that. Most subsidies cases are what are called here countervailing duty cases. They're just like dumping cases. Someone files a petition at the Department of Commerce and the International Trade Commission. If you find subsidies and injuring, they get special duties, okay? But some subsidies are also actionable directly in the WTO. This is different. Now, this is not a remedy for a private company. The WTO, you know, the parties are governments. Okay, these are government to government. So the big place these remedies have been used is the Airbus-Boeing dispute. And this has been going on for, what, 20 years or something. Boeing brought, you know, well, the United States on behalf of Boeing brought big cases against Airbus, and Airbus brought big, you know, the EEC through, rather the EU now, probably was the EEC when the cases were brought. The EU brought big cases against the United States, you know, to go after subsidies to Boeing. Both sides were subsidized, both sides lost. The subsidies to Airbus were larger than the subsidies to Boeing. Now there's been recent developments in the compliance phase. Most recently, I think a WTO panel found that the United States had not fully complied with its obligations to phase out its subsidies. I haven't been following this extremely closely, but I think the same thing's also true in Europe. So now both sides are required, they will acquire tit-for-tat retaliation rights against one another, and they'll go back and talk some more, and you know, this has been going on for a long time. And I believe that Canada and Brazil have one as well. It seems to be an aircraft area. You know, Canada has Bombardier and Brazil has Embraer. You know, these are the smaller, under 100 or about 100-person jets you take. And those two have a long-running dispute going as well, I understand.
I have one final question. Is it true that the United States prevails in over 80% of the cases brought with the WTO?
I don't actually know that statistic. You know, do you mean brought by the United States or brought against the United States? But because the real rule, if you want a rule to predict the outcome of a case in the WTO, that rule would be complaining party wins. That's the best rule.
Yeah.
It's not always true, of course, but
you know, I don't know. I think I read, I now can't remember, but that the United States either prevailed, so I assume either the United States won or the United States defeated a claim brought against it in over 80% of the cases before the WTO.
You know, they say there's lies, damned lies, and statistics. That there's probably a statistic out there that's true. It's very difficult to keep score. For example, let's suppose that the Department of Commerce places a dumping remedy on, you know, widgets from France, okay? And then France, the European Union challenges the measure of the WTO. Typically, they will say, the Department of Commerce did 10 things wrong. And let's say the panel agrees with them on 5 of those. So, we lost. But what's the effect of changing those 5 things? Does the order go away? Do we have to, you know, or do we just change the number? Or do we drag it out for many years? You know, it gets maddeningly difficult to define success or failure. If a single practice can be identified so that it's really kind of a single bullet type of case, then it would be easier to score. But usually they tend to be very complicated. Again, take this Airbus-Boeing dispute. You know, it really was. I mean, everybody knew there were subsidies on both sides. It really got to be an issue about how many billions there were, and then of course once you find a subsidy, let's say you find that, you know, I don't know, that Airbus has received $1 billion, which would not be a lot of money. Then, you know, you have to allocate the subsidies. So how much is that per plane? Okay. Well, then you ask Boeing. I mean, you ask Airbus, and they'll say, well, of this model, say the new A380, you know, we're going to sell 1,000 of those things. You know, so the subsidies per unit is not that big. Well, then Airbus ends up selling 100 of them instead of 1,000. Well, then now the number's 10 times bigger. So, you know, it just, like everything else, you know, it's really difficult to define, or still less quantify, what winning and losing means in these.
Well, I want to thank everybody again, and let's give a big round of applause to John for coming out. And I just want to thank, I first want to thank a couple people. I want to thank everybody at the Dole Institute for doing such an amazing job and being so supportive of this discussion group. I want to thank Bill, Angie, Mark Crabtree. We've had 2 amazing discussion group coordinators that I've been able to work with, Haley Peterson and Alex Murray, who are in the back, who've done a tremendous job and been tremendously helpful in making this series a success. It has been such a privilege to be able to have this discussion with everybody, and I really appreciate everybody coming. Hopefully you feel like you learned a little bit more about a really complicated, really important topic that is dominating the headlines. And to all the students, I've been so impressed with all the students that I've gotten a chance to meet through this. And I'm really excited, and I really look forward to coming back here and being able to see you leading these discussion groups and you being our guest, talking about the amazing, great, and interesting things that you're doing in your careers, because I've no doubt that you will do those things. And so just want to thank everybody for what's been a great session. So thank you so much. Good job. That was great.